Thank you. We'll try to keep the trains running on time and people can fill in their seats as we get started. We'll resume now with our second panel, APA Reform, What's on the Table. I'm pleased to introduce the panel's moderator, PRIM ESCALONA. PRIM serves as the Principal Deputy Assistant Attorney General for Legislative Affairs, helping manage the department's very important relationship with Congress. Prior to her role at DOJ, PRIM was in private practice at Maynard Cooper & Gale, based in Birmingham, Alabama. PRIM has previously served the public in a variety of roles, including as Deputy Solicitor General for the state of Alabama, law clerk for Judge William H. Pryor of the 11th Circuit, and legislative assistant for former Senator Jeff Sessions. PRIM holds a law degree from the University of Alabama. I'm delighted to turn things over to PRIM.
Thank you. Good morning. We're going to get started with our second panel, APA Reform, What's on the Table. The legislative amendments to the APA have been few and far between since the law's enactment 73 years ago, but that isn't for a lack of ideas. Over the past decade, Congress has considered a number of bills that reflect a range of reforms, from expanding hybrid and formal rulemaking to broadening the scope and rigor of judicial review. We are fortunate today to have with us several experts on the legislative efforts to reform the APA. I'm going to introduce them now. We have Christopher Walker with us. He is a law professor at The Ohio State University Moritz College of Law. Prior to joining the faculty, Professor Walker clerked for Justice Anthony Kennedy on the Supreme Court and worked on the civil appellate staff here at the department. His publications have appeared in the California Law Review, the Michigan Law Review, the Stanford Law Review, and the University of Pennsylvania Law Review, among others. Outside the law school, he serves as one of 40 public members of the Administrative Conference of the United States and as chair-elect of the American Bar Association's section on administrative law and regulatory practice. Next, we have Amanda Neely, who serves as the general counsel to Senator Rob Portman of Ohio, as well as Deputy Chief Counsel of the Senate's Permanent Subcommittee on Investigations, which is chaired by Senator Portman. Ms. Neely handles Senator Portman's regulatory reform and infrastructure permitting legislative portfolios, including the Regulatory Accountability Act. From 2015 to 2017, Ms. Neely served as the Oversight Counsel on the U.S. House Committee on Ways and Means. Previously, she was also an associate at the Washington, D.C. Office of Gibson Dunn and served as a law clerk to then Chief Judge David Sentell on the U.S. Court of Appeals for the D.C. Circuit. Ms. Neely graduated with honors from Duke University School of Law and Princeton University. We also have Ronald Levin, who is the William R. Orthwein Distinguished Professor of Law at Washington University in St. Louis and specializes in administrative law and related public law issues. He has published numerous articles and book chapters on administrative law topics, including judicial review, rulemaking, and legislative reform of the regulatory process. Professor Levin has been active in the ABA section of administrative law and regulatory practice for more than 3 decades and served as its chair in 2000 to 2001. He currently represents the section in the ABA House of Delegates. He is also a senior fellow of the Administrative Conference of the United States and has chaired its Judicial Review Committee. And finally, we have Daniel Flores, who is the Chief Republican Counsel for the House Judiciary Committee's Subcommittee on Antitrust, Commercial, and Administrative Law. A graduate of Yale Law School, Mr. Flores has served on the subcommittee since the 110th Congress. He has been involved in all major regulatory reform efforts on which the committee has worked during his tenure, including reform of the APA and other major regulatory process statutes. He serves as a legislative branch liaison to the Administrative Conference of the United States and is a member of the Section Council of the ABA's Section of Administrative Law and Regulatory Practice. He previously served in the U.S. EPA's Office of General Counsel and the Environmental Defense Section of the Justice Department's Environmental and Natural Resources Division, as well as in private practice in Washington, D.C. Our panelists will now take a few minutes to provide a brief overview of the history of the APA, and we'll discuss some of the existing reforms being considered by Congress. We'll then turn to a moderated-led Q&A.
Great. Well, it's great to be here, and Solicitor General Francisco started us off on the right foot. It covered a fair amount what I wanted to start out with, which is the APA is going to celebrate its 75th birthday in 2021. It was a a fierce compromise that took over a decade of negotiations between Republicans and Democrats to reset or to set the ground rules for the modern administrative state. A lot of us, including Justice Scalia and others, have said this is the quasi-constitution of the administrative state. And yet, in the last over 7 decades, it's only been amended, Westlaw says it's been amended 16 times. I think I've counted more, about 19 times in those 7 decades. And so it's a document that hasn't been, a statute that hasn't been amended that often. Now, if you look at how it's been amended, there have been 4 major amendments. In 1966, the Freedom of Information Act was enacted. In 1974, we had the Privacy Act and the Government and Sunshine Act. And the 4th major legislative change, I would say, would be in the 1970s, 1976, there were a number of amendments, including addressing the waiver of sovereign immunity. If you want to read more about that, Katie Kovacs has a great article called Scalia's Bargain that talks about that. But aside from a modernization amendment in 2016 to the FOIA section, it's been over 20 years since we've had any amendment to the Administrative Procedure Act. And it's been over 40 years since one of these major amendments back in the 70s. So this is a statute that has stayed, at least on the books, relatively the same as it was in 1946. Yet, a lot has changed in the modern administrative state. Aaron Nilsson covered a lot of that ground in the first panel about the changes to the formal procedures of the Administrative Procedure Act. I want to flag 2 other, I think, major changes that we've seen in the modern administrative state. The first one is covered well in a fabulous article by Ann Joseph O'Connell and Dan Farber called The Lost World of Administrative Law. Their main point is that the reality of how administrative law functions today has departed dramatically from the text of the Administrative Procedure Act and the assumptions that motivated the Administrative Procedure Act. The way they kind of frame it, I like it, they say, there's an increasing mismatch between the suppositions of modern administrative law and the realities of modern regulation, or to put it another way, administrative law seems more and more to be based on legal fictions. One of the ways that they point this out that Aaron didn't cover, he's covering a lot, is that we've seen a shift in focus from adjudication that was heavily negotiated in the Administrative Procedure Act to rulemaking. One way that O'Connell and Farber capture this is by looking at casebooks. I think this is pretty fascinating. The Gellhorn and Bice casebook, even up to the mid-1970s, devoted only 22 pages to rulemaking. Yet 2 chapters, 281 pages to adjudication. There was a 100-page section on judicial review. It had only 8 pages on review of informal actions to tie back to Aaron and the first panel. The first edition of the Davis casebook in 1951 dedicated only 3 pages to notice and comment rulemaking, though it gave a whole chapter to formal rulemaking, which uses, as Aaron explained, these kind of more formal adjudicative processes. So one big change is we've had this shift from adjudication to rulemaking. The other big change is we've also have a shift from legislating to rulemaking. I went and gave a talk to all the 3rd graders at my son's elementary school this week about, they're covering civics and the 3 branches of government, and so I showed, of course, my favorite video, Schoolhouse Rocks, How a Bill Becomes a Law. And as I showed it 5 times, because 5 different classes, I was like shocked. I wanted to say, that's not where most lawmaking happens today, right? To give like one snapshot that'll probably drive Ron Levin crazy, the 114th Congress passed 329 public laws, a total of 3,000 pages in the statutes at large. Federal agencies during that same time promulgated more than 7,000 final rules that I think were up to 80,000 pages in the Federal Register during those same 2 years of final rules. Not overall, there are over 100,000 pages. So if you get a sense of the degree of where our lawmaking happens today, it's happening at these federal agencies, and this is something I'm sure that the founders of the APA, and we'll call them founders because it is a quasi-constitution, had never contemplated that we'd have this huge shift away from Congress and that we'd have a shift away from adjudication and towards rulemaking. So there's a need for some reform. Now, I don't want to spend a lot of time on this. This doesn't mean that the Administrative Procedure Act hasn't changed. It's changed a lot. And what we call administrative common laws, Julian Metzger, John Duffy, and others have explored in depth. We have a lot of ways in which the court has interpreted, might be one way to say it, or rewrote, might be another way to say it, the Administrative Procedure Act. Just to tick off a few examples, judicial deference doctrines like Chevron and Auer, hard look, arbitrary capricious review, remand without vacature, basically eliminating formal rulemaking, as Aaron Nilsson mentioned in the first panel, more rigorous requirements for notice and comment rulemaking, as Professor Nilsson also mentioned. John Duffy has flagged the exhaustion of administrative remedies. Katie Kovacs has flagged the issue of prudential ripeness doctrines. Nick Bagley has a great piece on the presumption of reviewability. And most recently, as was said at the outset, nationwide injunctions as another one that a number of people, including Sam Bray, have argued is inconsistent with the Administrative Procedure Act. And so while Congress has done very little to tinker with this governing, super statute of the administrative state, courts have had to step in and do a lot of that. And for some of us, that makes us a little uncomfortable, that you go and you read the Administrative Procedure Act, and if that's all you read, you'd be a very, very poor regulatory lawyer when it comes to actually dealing with the administrative state. So modernization of the Administrative Procedure Act is needed, but it shouldn't be done by courts. Congress really needs to step up and do that. And so at that point, I'll just kind of turn it to the folks that actually are working on this on the Hill.
Thanks, Chris. I think what Chris is telling me is that I need to start doing my job better. Thank you. But seriously, thank you to DOJ for having us here today, to Deputy Attorney General Rosen for hosting this, and PRIM for that kind introduction. I have to offer the standard government caveat, which is that all opinions are my own and do not necessarily reflect those of the Senate or Senator Portman. While the administration has been busy over the last few years rescinding and revising substantive regulations, the action in Congress has really focused on reforming the process by which agencies create regulations. And I'm really glad that DOJ is hosting this conference today. I feel like last Congress we saw a lot of events like this. I think it's telling that this is the first panel I've sat on regulatory reform this Congress. The action has slowed down a little bit in Congress, but I hope we can pick it up. And I think events like this are really useful for drawing attention to needed regulatory reform. So to give us a structure for what I think the rest of the panel will address, I'm just going to give a quick overview of three of the main overarching regulatory reform efforts in Congress. And those are the REINS Act, the Regulatory Accountability Act, and some piecemeal reforms, which are incidentally organized probably from the least to most likely to get enacted in the near future. The REINS Act, REINS stands for Regulations from the Executive in Need of Scrutiny Act. It is a bill that would require Congress to pass a resolution of approval in order for a major rule to take effect. And major rules are those that would have $100 million or more annual effect, or a significant increase in costs on consumers, or significant adverse effects on the economy. Congress would have 70 legislative days to consider each major rule, and if Congress did not pass a joint resolution approving that rule, it would not go into effect. And although the bill also creates an expedited procedure for the Senate floor, it has been criticized because it would slow down the rulemaking process and occupy a significant amount of floor time in the Senate, which, as we all know, is a very limited commodity already, particularly with the nominations process taking a little longer than it used to. The Government Accountability Office has reported that over the last 10 years, agencies usually issued about 50 or 60 major rules each year, with a peak in 2016 of 120 major rules to a low in 2017 of about 50. That number has crept up a little bit in the last couple of years, but not much. So that would mean somewhere between 100 to 240 Senate floor hours each year devoted to considering major regulations if the Senate took up every major regulations. And in a divided government, it would admittedly make it more difficult for agencies to actually promulgate and enforce new major rules. But I think that bill is a really helpful reminder that agencies are acting on congressional authority, and we need to find ways to reinvigorate congressional oversight of agency action. Second major reform, it's my favorite, it's the Regulatory Accountability Act, and I handle that bill for Senator Portman. He has introduced the bill in every Congress since he's been a senator. It would be the first major overhaul of the Administrative Procedure Act since it was enacted in 1946. And that sounds revolutionary, but many of the parts of the RAA would simply codify and make enforceable current practices that exist under executive orders like EO 12866. And many of the ideas are based on recommendations from organizations like the American Bar Association and the Administrative Conference, or since we have introduced the bill, they've gained the endorsement of those organizations. It would improve the transparency of rulemaking by requiring agencies to engage really early on in the rulemaking process with public outreach through a notice of initiation of rulemaking, which sounds a lot like an advance notice of proposed rulemaking, but would actually back the process out even further to say the agencies would have to say, here's a problem, public, what are your thoughts? How do we solve this problem? Rather than saying, here's how the agency is thinking about solving the problem. It would also codify OMB good guidance practices that Senator Portman created when he was the OMB director to ensure that agencies don't use guidance to skirt rulemaking procedures. We think it would improve the quality of rules by requiring agencies to rely on the best reasonably available scientific data, and by requiring agencies to consider a reasonable number of regulatory alternatives, which we have proposed would be roughly around 3, which is similar to Circular A4. The RAA would require agencies to engage in a more robust cost-benefit analysis, and those are for the major rules, and to maximize the net benefits of rules, looking at the costs and benefits within the scope of the statutory provision authorizing the rulemaking. It would allow parties affected by some of the biggest rules to request an agency hearing to examine the facts underlying the agency's proposal, which would draw us a little bit more toward the formal rulemaking process. And it would apply some of the same analytical requirements to both independent agencies and executive branch agencies. Last Congress, the Senate Homeland Security and Governmental Affairs Committee reported the bill on a bipartisan vote, and since then, Daniel and I and others have been working with the administration and folks across the aisle to improve the bill. And there are a number of other bills out there to improve the regulatory process that are more piecemeal. I think Daniel's going to touch on some of those. Senator Portman has 2 of them, one that would say that independent agencies could come under presidential EOs, which is to affirm that authority, to subject them to the same regulatory analysis requirements as executive branch agencies. We also have the Unfunded Mandates Accountability Act, which would update the Unfunded Mandates Reform Act. And then Senators Johnson and Langford also has some good ideas regarding guidance and advance notices of proposed rulemaking. The road to enactment is long. It's hard to pass anything in Congress right now, as you all may have seen. But I've got some hope for the future. In 2017, Cass Sunstein, one of President Obama's OIRA administrators, wrote a column with my favorite headline of that year. It was entitled, "A Regulatory Reform Bill That Everyone Should Like." And about the co-sponsors, he said, they've produced an intelligent, constructive, complex, imperfect bill that deserves careful attention. I appreciated that assessment, and I hope we can continue to work on constructive efforts going forward together. Ron?
Okay. Well, thank you, and I appreciate the opportunity to talk to you today. In case you haven't figured it out yet, I am the Regulatory Accountability Act skeptic on this panel. My involvement in the current regulatory reform debate stemmed from my participation in writing comments of the ABA Administrative Law section on the initial House version of the RAA. Those comments endorsed some provisions of the bill and criticized other provisions. And since then, I've done more writing about the bills individually. I've continued to support some aspects of the RAA and to cast doubt on the wisdom of other aspects. During 2015, I participated in a project by the ABA Administrative Law Section to develop a set of American Bar Association recommendations for revision of the APA. And that was a truly cooperative endeavor among members with a wide variety of political points of view. Jeff Rosen was chair of the section at that time and a principal mover of the project. And I was the section's delegate who actually presented the recommendations to the House of Delegates, which adopted them without opposition. The resolution contained a variety of measures that would codify rulemaking procedures that are already widely observed or that would make minor adjustments in the existing APA rulemaking structure. They included, for example, codification of the Portland Cement Rule, which, as you've heard, requires disclosure of the factual data underlying a proposed rule, and creation of a procedure by which members of the public can nominate existing rules as promising candidates for retrospective review, and explicit authority for an incoming presidential administration to delay the effective date of midnight rules for a short period so that it can study them. Each of these ideas did appear in one or more versions of the RAA, and as far as I can see, APA revision proposals like these would stand a good chance of passing Congress with broad bipartisan support. On the other hand, the RAA bills also included a number of more drastic and provocative proposals that, in my view, should never have been on the menu in the first place. And in the limited time I have left, I will mention a few of these. First, as has been discussed, the bills would have provided a right to trial-type hearings to resolve technical issues in high-cost rulemaking proceedings. This is a procedure that Congress has completely stopped adopting over at least 4 decades. So the claim that resurrecting it is a good way to modernize the APA seems odd to me. But more substantively, no one has demonstrated any need to resuscitate this long disfavored procedure. As best I can discover, none of the RAA proponents has cited a single example of a rulemaking proceeding conducted during the past 40 years in which, according to them, they were unable to make their case effectively using notice and comment rulemaking, but could have done so if trial-type procedure had been available. I think the burden of justification should rest with those who would depart so dramatically from the status quo, and I think they've not really tried to carry it. Second, the bills would have prescribed a variety of so-called rulemaking considerations that an agency would be required to address in every rulemaking proceeding. And unlike the executive orders from which they are drawn, these requirements would be judicially enforceable. But why insert these requirements into the APA with all the litigation encouraging consequences inherent in that move? If an interested person wants the agency to address these or other considerations, all he has to do is file a rulemaking comment, because the agency has a duty to respond to all significant comments. I see no reason to require an agency to address a variety of issues that nobody chose to raise. Third, the bill prescribed judicially enforceable cost-benefit analysis obligations for major rules. Now I do support cost-benefit analysis as it currently operates under Executive Order 12866. That is, courts don't enforce compliance with the executive order as such, but the cost-benefit analysis becomes part of the rulemaking record, and the agency needs to respond to its conclusions in order for its regulation to survive judicial review on the merits. That system has worked reasonably well for decades, and I doubt that we need to supplement it with a regime in which a failure to comply with each and every one of the detailed and technical requirements that, for cost-benefit analysis becomes an error of law that could result in the courts setting the rule aside. Judicial application of the vague terms of the APA amendment with de novo review, because it's part of the APA, would call for sophisticated policy analysis judgments that are out of sync with the tasks that we usually ask generalist judges to perform. Fourth, and relatedly, I recognize that many lawyers favor the RAA because the bill would extend cost-benefit analysis requirements to major rules issued by independent agencies. However, a much better way to accomplish that goal would be through a different bill that Senator Portman has sponsored, the Independent Agencies Regulatory Analysis Act. Essentially, that bill would bring independent agencies into the Executive Order 12866 regime. And I'm a public supporter of that bill. Broadly speaking, it would accomplish the same result without the judicial review complications that would result from incorporating cost-benefit criteria into the APA. And it would probably be more politically saleable as well. So because a better solution is available, these lawyers' goal does not seem to me a good reason to support the RAA. And finally, I should say a word about the REINS Act, which Amanda brought up. This is a measure that I consider grossly unworkable. Just imagine the difficulty of getting the agency, the House, the Senate, and the President to agree on the terms of a complex, economically significant regulation which they cannot amend. And imagine having to do this in a period of divided government in which partisanship and lack of compromise are commonplace. And then bear in mind that this regulation would also have to survive hard-look review on the merits. Add it all up, and major rulemaking under the REINS Act would become next to impossible, a result that I consider unacceptable. So to sum up, the most promising pathway to APA revision, in my view, is to abandon dubious and divisive proposals like the ones I have just mentioned. And instead, the sponsors should narrow the RAA to encompass only moderate measures like those in the ABA resolution, measures that probably could elicit buy-in or at least acquiescence from lawyers across the political spectrum. It seems clear to me that in a period of divided government, that approach is the most constructive option if the goal is to move beyond political messaging and wind up with enactment of durable legislation. Thank you, and I look forward to further discussions with the panel.
Hi, I'm Daniel Flores. I want to thank the department for holding this summit, and I want to echo Solicitor General Francisco's comments about how important the department was to the original framing and enactment of the APA. So we're in debt to the department today and have been for quite some time. I'd also like to offer a caveat, as Amanda did. You know, my views that I'm expressing this morning should be taken as offered in my personal capacity. I'm not speaking on behalf of Ranking Member Collins of the committee or of the committee. But what I'd like to do is share with you some thoughts about the big picture here and how it has informed efforts in Congress to pursue Administrative Procedure Act modernization. As we all know, a vast amount of federal lawmaking has been undertaken over the years to regulate the American economy. And our focus today is on lawmaking that happens through rulemaking by federal agencies. For years, the number of new federal regulations promulgated each year has exceeded 3,000. There are numerous estimates of the burden this regulatory output has placed on the American economy. To choose one that is based on compliance cost figures agencies themselves have relied upon in their own official cost estimates, as well as economic and gross domestic product losses and social costs. One prominent think tank here in Washington last year estimated the total annual burden to be $1.9 trillion. That is equivalent to more than 40% of annual federal spending and 9% of the United States gross domestic product. It rivals total U.S. individual and corporate income taxes. Spread over all U.S. households, it would equal $14,615 per household, equal to 23% of median U.S. household income in 2018. If these costs were the GDP of a country, that country's economy would be the 9th largest economy in the world. No one disputes, and this applies to Congress, and I'm sure to all of you here, that many benefits have been achieved by federal regulation. But those cost figures I just cited to you are figures that I think should take one's breath away. Given how long we have been at the regulatory grindstone, it would be wise, I would suggest, to bear in mind Associate Justice Stephen Breyer's observation during the 1990s that it can become extremely costly to harvest the last 10% of benefits. In the current economic environment, there is more reason than ever to bear that observation in mind. America is no longer the lone economic giant it was in the post-World War II era when the APA was framed and practice under it developed. China is looming very large in our rearview mirror and attempting to pass us, and it is far from the only evolving competitor we front. At a minimum, I would submit we should be thinking of ways in which to make sure that new regulation is more cost-effective and efficient as it seeks to attain new benefits. And Congress has been thinking about that hard for some time now. Let me offer you one additional perspective. The 3,000 plus regulations issued each year dwarf the number of statutes enacted each year, as Professor Walker alluded to earlier. The typical ratio is greater than 10 to 1. As we all know, the framers established a rigorous system of checks and balances to constrain the ability of Congress to legislate unwisely and end up doing more harm than good. The APA establishes constraints as well, but by comparison, they are quite light-handed. An agency can easily propose a preferred outcome, go through the motions of notice and comment, shrug off objections to its preference, promulgate its preference, and see its preference survive judicial review, so long as the agency's choice wasn't arbitrary or capricious and displayed a minimally rational connection to the administrative record. It is a fair question to ask whether over 90% of lawmaking happening under our Constitution should happen without more requirements than that to guide it. And Congress has asked that question. On the House Judiciary Committee, efforts to undertake APA reform began in the late 2000s during the 110th Congress, based in large part on these considerations. This was part of an overall project to strengthen administrative law, following up on sustained oversight the committee had done in the preceding two Congresses. The fundamental concept has been always, first, to strengthen the central edifice of the APA, and second, to improve the buttresses around it. So thus arose the Regulatory Accountability Act, along with the REINS Act, the Small Business Regulatory Flexibility Improvements Act, and other surrounding bills. In the RA itself, the central concept was to look to modernizing tools that had already been proven to work and had inherently bipartisan support. The committee looked largely to Executive Order 12866, as Amanda mentioned, and related executive orders, and sought to render into statute core elements of those orders that actually could be rendered readily into statutorily binding terms. And as it did that, Congress tried to focus, or the committee tried to focus, on the rulemakings that were most important, which are the major rulemakings. Developmental work on the bill continued throughout the 111th Congress, grew to include the Senate, and ultimately yielded bipartisan, bicameral companion bills offered first during the 112th Congress by former Chairman Lamar Smith and Representative Peterson of Minnesota in the House, and Senator Portman and former Senator Pryor of Arkansas in the Senate. As one can see by looking at the bill, we included the basic menu of rulemaking considerations Professor Levin mentioned. Other key provisions of the bill increased the use of advance notice of proposed rulemaking for major rules, instituted a statutory cost-benefit analysis requirement, included a final standard that would better ensure the benefits of final rules justify their costs, increased retrospective review for major rules, and adopted basic corresponding reforms for major guidance. There has been discussion along the way about whether some portions of the bill ought to or ought not to be there, but at least three things have remained very consistent. Bipartisan, bicameral sponsorship in recognition of the need for modernization, the overall contours of the bill, and the big picture economic considerations and constitutional considerations that should drive us all to the conclusion, I would submit, that the APA that was good for 1946 needs to be modernized to assure smarter, more cost-effective, more efficient, and more accountable regulation as America strives to compete in the 21st century. It remains our hope, as Amanda mentioned, that in the end we can effectuate this reform and modernize the APA based on sound reforms rooted in bipartisan thinking. So I look forward to the continued discussion and yield back.
Thank you, Daniel. The last panel and some members of this panel have been pretty pessimistic about Congress's ability to pass any reforms in this area, or maybe any area. In our current political environment, Daniel, Amanda, is passing a bipartisan APA reform package really realistic?
I'll start on that. I think it is. I think it is. Largely for reasons I mentioned, which is that there's a sound common sense case to be made for modernization. It's long overdue. There's always been bipartisan support for the legislation we've undertaken. We in fact came extremely close last term to getting legislation done. In the end we didn't, but we are keeping at it, and we hope that in the future we'll be able to get it done.
I think the RAA has some selling points that should be appreciated by both parties, primarily that not only do Democrat administration's regulations have to go through increased scrutiny, so do Republican administration regulations. When I was working with Senator Heitkamp's staff, we reached a compromise to say not only do regulations that have $100 million or more in cost to the economy, but also those that just have $100 million or more effect on the economy should get the same level of scrutiny, just because these are going to be very big rules that have a very big effect on the economy. And that would include rulemaking proceedings to rescind or amend previous rules. So I think that if we continue to talk about those aspects of regulatory reform and continue to work in good faith with each other, which I think we set a really good precedent over the last few Congresses, or Senator Portman has with Senators Heitkamp and Pryor and Manchin. It will be more likely that we will be able to move something in the future.
And if a package were to move, what is each of your, in your view, the number one item that must be included in any final package?
I'll jump in on that one too. Of course, I have to defer to the members on this. My own personal view is that at least a good candidate for that would be a standard for final rules that assures agencies always do more good than harm, with an emphasis on the benefits being achieved being within the scope of the statutory provision being implemented, exceeding the costs of achieving those benefits.
Similarly, I would say, and again, my own view, but increased cost-benefit analysis and transparency that is judicially reviewable to hold agencies accountable to doing their homework and doing it publicly.
I don't think I would endorse that one. But as I was saying earlier, there are provisions in the RAA that already have support from the ABA, the Administrative Conference, that can be accepted across the political spectrum. Some of my fellow panelists are talking about bipartisanship in a different sense from what I have in mind. Getting 2 Democratic senators to support an otherwise completely Republican supported bill is one definition of bipartisan, but I would be thinking more of things that would have broad support across the spectrum of the kind of things I mentioned would fall in that category. And having judicially enforced cost-benefit criteria where the courts are managing the intricacies of cost-benefit criteria would not be in that category, and in my view shouldn't be.
So I don't know if I have like one favorite, but I do think the architecture, at least of the Senate version of the Regulatory Accountability Act, that recognizes that process goes with how important the rule is a really important feature. I mean, the elephant in the room is the non-delegation doctrine and issues of the idea that agencies are deciding really big, important questions that maybe Congress should be the ones that decide, right? And I think when you look at the Regulatory Accountability Act, you know, Ron gave a good critique of the formal-ish rulemaking requirements that would be required, but those would only actually be required for $1 billion rules. And the fact we're even talking about $1 billion rules kind of scares me. That's really not what, you know, hopefully we're, you know, and then for $100 million rules, they can be required, but agencies have some flexibility to say they're not needed. And I think that's the important essence, is that for your run-of-the-mill, everyday rules, the requirements of economic analysis and others are going to be much, much less stringent, if not non-existent. But the more expensive or the more important the rule gets, the more process that we want the agency to have to go through in order to make sure that they make the right decision, so that it elevates the issue from a resources perspective to Congress's attention and the like. And I like that part of that, the idea of the architecture behind it, of really trying to tie process to how close you get to a non-delegation issue.
And to be clear, that would be only about 1 or 2 rules a year max, usually.
But if that's not bipartisan on $1 billion rules, I mean, I don't know what, I don't know.
Well, I can't speak for the Democrats in Congress who are not represented on this program, for whether you think that's a good idea or a bad idea. But my own view would be, no, it's not a good idea. You heard Aaron say in the previous panel that cross-examination has its uses in some contexts, but maybe not for scientific and technical points. Well, that is what would be the subject of this hybrid rulemaking under the bills. It's a mismatch, in other words. And I don't think you should bring in procedures that are dysfunctional and thereby delay or impede the adoption of rules in which, yes, there could be $1 billion cost, but by hypothesis, the agency proceeds and will have to make a case that the benefits far exceed that. So be cognizant that rules bestow benefits and don't adopt procedures that make it overly difficult to bring those benefits to the public.
Yeah, perhaps I could jump in. You know, as a former DOJ litigator, I could ask the audience. Some of you are fitting that description. Some of you litigate against those litigators, but you're litigators, and I would suggest that you know, a good litigator would understand the benefits of cross-examination in cases of that magnitude that they are handling in front of the courts. And I can recur to one of my most vivid memories of my litigation days involving a case about safe drinking water standards in the DC Circuit, in which we had a 3.5 oral argument that was largely dominated by former Chief Judge Garland, exploring very deeply the very deep administrative record over the scientific and technical issues that were informing those standards, which were for radionuclides in drinking water. So I think the courts are up to it. One of the key things about the architecture of the bill, to which Chris alluded, is that there's really an emphasis on opening up earlier the process of the formation of the record to the public to get more good information in front of the agency, better inform its choices, better inform its decision making, and ultimately bump out a much more robust administrative record that can enable the courts to engage in the searching review that they should.
Can I just add one other quick point on that? Well, I think on the formal rulemaking, I think Aaron's article actually is that if it is a scientific issue, that is good for cross-examination, but I could be wrong. The other point on the architecture of the Senate bill I want to point out is that I like how the Senate version would change our deference to agency regulatory interpretations to Skidmore, but it would preserve Chevron deference. And I think that's important, although the House bill didn't have that, because if you're going to make rulemaking harder in some circumstances for higher impact rules, you want to still encourage the agency to engage in that rulemaking.
Yep.
By preserving Chevron, it keeps the reward there, and I'm borrowing from one of Aaron Nilsson's prior articles. But it kind of takes the reward of going to the substitute of guidance instead of rulemaking.
Maybe I could offer a general correction there. Actually, the Regulatory Accountability Act proper never has taken on Chevron deference. We had an omnibus Regulatory Accountability Act included other titles last term in which the Separation of Powers Restoration Act, which would legislatively overturn Chevron, was included. But the RAA in the House and the Senate, strictly speaking, has been of the nature that Amanda described.
Can I respond to Chris on that issue as well? No, it did not undertake to codify Skidmore. It undertook to adopt a test that looked a little bit like Skidmore, but changed some of the language, and so the bill that came out of Amanda's committee would have proposed adopting a totally new, totally untested standard of review for review of interpretations of regulations. I think Congress should not be legislating on that point. I've said, you know, REA, APA reform in general can be pursued in a number of ways, but I think the court should stay out of scope of review because they don't do it correctly.
Courts are Congress.
What?
Courts are Congress.
Congress should stay out of it because the courts are in fact doing it. I mean, our deference was examined extensively and closely by the Supreme Court last term, and they wrote an opinion that is detailed in some ways, but also susceptible of evolution. And so I think that's the right way for it to be handled. Whereas if you codify things, you can be overly Procrustean, and you can sometimes make drafting mistakes. And as Amanda's bill also provided that a policy statement may not be reviewed for its constitutionality or for being ultra vires. I don't think they intended to do that, but it's what it plainly says. Congress, I think, should leave that type of work to the courts.
Yeah, I would vigorously attempt to rebut that assertion. The APA, after all, itself, in its original 1946 terms, broadly defines the scope of judicial review, and that's entirely appropriate, because what is happening in cases brought under the APA is challenge to final agency action under a waiver of sovereign immunity. The sovereign is entirely entitled to define the terms through which the review happening under the waiver should take place. And Congress has proven quite able to do that. And I remind everybody that Congress also, by statute, has adopted the Federal Rules of Evidence, the Federal Rules of Civil Procedure, the Federal Rules of Appellate Procedure, et cetera, et cetera. So Congress knows how to deal with judicial review provisions. It typically does them in concert with the expertise residing and the authority residing in the judicial branch. And so there's quite a bit that we can access to make sure that we make good decisions. But in the end, we're talking about waivers of sovereign immunity and how they're framed. So,
Amanda, do you have any thoughts on that?
Amanda's bill.
Yes, Amanda's bill. Senator Portman will not be-
Amanda was recently elected to the Senate.
Thank you for the promotion. I agree with Daniel, no surprise, that Congress is perfectly capable of dealing with standards of review. And relying on the Supreme Court to solve our problems for us, I think is inappropriate, and we're doing it way too much these days. I think the Supreme Court, I'm not speaking for them, but my sense is that they feel like we're relying on them way too much to solve our congressional problems these days. And again, we tried to take a relatively modest approach in the Senate RAA with addressing the hour issue and requiring courts to look at agency interpretations of their own regulations based on the evidence and the support that the agencies provide for those interpretations. And we think that provides a little bit more accountability for the agencies to write clear regulations. And we don't take on Chevron because we do understand that that would be politically infeasible these days, frankly. So no, I agree with Daniel that it would be an appropriate measure in the RAA.
We've talked a lot about a big package, the RAA, or a more comprehensive reform. We know that oftentimes in Congress, it is very difficult to move a big package or a big vehicle through both chambers and then to signature by the president. Are there smaller things that could be done that would have that bipartisan support that would be able to move either by UC or some other vehicle, be attached to some other vehicle that would be impactful?
There are smaller proposals out there. I think Ron and I both mentioned the Independent Agency Regulatory Analysis Act, which would just simply state that it would affirm that the president has authority to bring independent agencies under executive orders requiring cost-benefit analysis. Even more restrained measures like that have struggled to get bipartisan support right now. And that's been an interesting development. Regulatory reform has largely, historically, been more of a bipartisan exercise, and right now the dialogue on everything is a little bit heated. So I think over time, people will maybe come back to having interest in those more restrained measures. Senators Langford and Sinema, New Congress, have a good proposal on advance notices of proposed rulemaking that have gotten some good support in committee. Senator Johnson had a good bill on just requiring agencies to post guidance online. I can't imagine how that receives any opposition, but maybe it does these days.
Yeah, I agree with Amanda. There are some good smaller bills out there. Some of them are attempts to excise one portion or the other REA and put it into a standalone bill. Others are of a different genesis, but there are some good ones. The AMPR's bill that Senator Langford had is one. A bill on retrospective review is another good one. Perhaps there could be a bill that would be smaller that could legislate a requirement for reply comments. That would be a good thing too. But I think the overarching imperative here is that the problem at hand with the current regulatory burden is so great that small measures aren't really adequate to the problem. If we were talking in 1960 or 1970 and taking a good look back at how the 46 Act were working, then I think it would be entirely appropriate to be focusing on smaller bore measures. But it's 2019, and the figures that I mentioned at the outset are real. There was another study that was done quite recently under the auspices of the Mercatus Center at George Mason that took a look at what the U.S. GDP would have been had federal rulemaking stopped in 1980. Essentially, if we didn't have the rules adopted since then. Obviously, a lot of very good rules have been adopted since then. A lot of very good benefits have been obtained. But what the study found was that the U.S. GDP right now would be 25% larger if that were the case. And 1/4 of U.S. GDP activity is also something that produces an enormous amount of benefits for America, its citizens, and the world. So I think what we need really is a bigger bore measure to make sure that as we achieve benefits, we do so in a way that is tractable, but it's more cost efficient, it's more cost effective, it's just plain smarter. And that's why we focused on the REA.
We know that when legislation is passed, there are always unintended consequences, right? What are your concerns about the unintended consequences of APA reform, if any? Professor Levin?
I think everything I was talking about was unintended consequences. But I'm not opposed to the idea of modernizing the APA. I think that makes some sense. And certainly, in some ways, it can be desirable to put some of what is already developed as common law into statutory forms so that you have a little more stability and a little more legitimacy. However, I don't think that we should rush ahead and do things that aren't thoroughly thought through. Administrative law has always had a very substantial common law component. It's not inherently bad to have it. If you can come up with good statutory reform, that is fine, but just because things are dealt with in case law is not a terrible thing in my view. It's an inevitable thing. And so we should be cautious about the unintended consequences of various measures. And I mentioned only a few, but the 40-page critique of the original REA bill that the administrative law section submitted has a lot of comments about the particulars, and I think would bear close attention if the REA gets reworked. I think as a first stab, there's a lot for us to talk about, but I think it needs substantial change. The original APA began as a strong counterforce move against the Roosevelt administration, against the New Deal, but it culminated in a compromise that was passed by Congress unanimously. I don't think we're very close to coming up with measures that would get that broad a support.
If I could jump in, I think it's an important question. It's one that we've wrestled with. We tried to deal with it accountably. I would just also put in a note of caution about the unintended consequences of the 3,000 plus laws promulgated by the federal agency each year. I think we'll have a whole lot more unintended consequences through them, particularly the major rules, which is why we need the kinds of reforms that we're trying to take on in the REA.
I'll just add a few other, obviously anytime you tinker with one process, the agency could shift to other processes, right? And again, Aaron Nelson's talked a lot about one worry is if you make rulemaking tougher, that they're going to switch to adjudication. or to guidance. On the adjudication front, I mean, we could have a whole panel on reforming adjudication, and would be a very hard panel to have. And there's a lot of issues there right now under the APA, but more importantly under organic statutes. And second, as Nick Perillo in the last panel with guidance, you can try to reform guidance, and I'm glad we're not diving too much into guidance there, because if you make it too hard, I mean, businesses want guidance too, right? I mean, Nick's report really does a really fair and detailed, exploration of the tensions for businesses between the benefits of guidances and the cost of guidance. And so I just think there are a lot of unintended consequences to doing reforms. You've got to think very carefully through that before you proceed.
Thank you. I believe that we are out of time. That was the red light came up just as you were finishing. I'd like to thank all of our panelists for being with us here today. Thank you all.